Hello, everyone. Let me be the first to welcome you to the new course for Trade and Customs Law Enforcement, False Claims, Litigation, and Forced Labor Detentions. I am Kevin Ekstrand, Vice President of Trade Compliance at Nuadam Logistics. I'm a licensed customs broker and certified customs specialist, focusing on United States regulatory compliance matters and serve as Nuadam Logistics Corporate License Holder Officer. It's a pleasure to be with you today to moderate this very timely and related topics. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the questions box. We will try to answer all questions during the webcast today, but if a fuller answer is needed, we run out of time, it will be answered later via email. A PDF of the presentation is available in the resources folder. This program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to our business needs. That is it for the housekeeping items. Let's get started with our program. We're excited to be talking with you today about recent developments in trade and customs law. So I'm pleased to first introduce you to our two speakers today. First is Jeffrey Neely. Jeffrey has more than 25 years of experience representing private parties in international trade remedies disputes in the U.S. and in foreign jurisdictions. He guides clients in matters including anti-dumping investigations, countervailing duties, subsidies, intellectual property disputes, as well as related customs, export control, and other important export issues. Next is Robert Stang. Bob focuses his practice on customs and international trade law. He brings 30 years of experience to a wide range of issues that affect inbound and outbound goods, including tariff classification, valuation, country of origin, marking matters, free trade agreements, and special trade programs. In today's presentation, I'm going to turn it over to the two gentlemen presenting, and then we will go through some question and answers as time allows at the end. So let me please introduce you to Jeffrey Neely.
Hello to everyone. Jeff Neely, and welcome to our webinar today. At first blush, the false claims issues and the forced labor issues don't seem to have very much in common, but we've combined them because both of these issues are increasingly important in the trade realm. And we're seeing both types of cases, which involve statutes that have been around for quite a long time, suddenly in the last few years become much more prevalent and much more important to the importing community. So we decided, since these are both sort of cutting edge issues right now and of concern to a great number of people, that we combine these in one webinar. So let me begin with the False Claims Act, which is my topic. The False Claims Act is a federal statute that traditionally has been used to address false claims by corporations, by corporations and individuals, where they wrongly claim money owed to them by the government. And many of these cases, as you would imagine, are traditionally involve things such as healthcare or Defense Department claims, where people have made unfair claims to the government and overcharged the government for things. But more recently, there have been so-called reverse false claims actions. And by reverse, they mean that is the money that is owed, not money that somebody got from the government, but rather involve money owed to the government that was not paid. Many of these reverse claims have involved failure to pay things such as anti-dumping duties, countervailing duties, Section 301 duties against China, or Section 232 duties on steel and aluminum products. The use of false claims actions really have bipartisan support in both the Congress and in the executive branch of government, which means that not only are they there, but we would expect them to be there for some time in the future. Companies that are found liable for false claims may be fined up to 3 times the amount owed plus penalties. Of course, if criminal activity is detected and found to be the case during the course of the civil case, there's also a possibility of additional penalties. Thus, these cases can turn into, in many cases, into a sort of bet the company problem. And so they are to be taken seriously in almost any case. An important segment of the false claims actions involves what are called qui tam actions. And qui tam actions are a sort of a type of whistleblower actions that have been brought by private parties. And usually they're filed in confidence in US federal courts. At the time that those actions are filed, they're served on the US government, which then decides whether to join in the action. But they're not served on the party that is potentially ultimately the defendant in these cases, but only on the government initially. The decision of the government as to whether it wants to participate in these qui tam actions brought by private parties will take at least 60 days. And oftentimes what we've seen is it takes much longer than that. If the government decides to participate in the case, it will take control as the plaintiff and move the case through the court system. The chances of success if the government gets involved and decides to take up the case are much greater than if the case is not taken up by the government. And that's probably not surprising because you have the full weight of the Justice Department behind the litigation at that point. If the government declines to take up the case, there still can be participation by the company that filed it initially. That company is called in the terms of the statute the relator. And they can still move the case forward through the court system, but the chances of success, go down considerably. But it can still be a substantial burden on the part of the defendant, of course, because you do have to defend after all. If the government intervenes in the case and the case is successful, either through a settlement or a trial, the whistleblower or the relator is entitled to 15 to 25% of the amounts collected by the government. So obviously in a big case, lots of money involved, that is a very, very big incentive on the part of relators to file such cases. And as I said, the relator could be an individual whistleblower or it could be a company. If the government declines to take up the case, and the whistleblower successfully pursues it on its own, the whistleblower reward is between 25 and 30% of the amounts collected. So, it's even more. But of course, at that point, the relator is going to have to do a lot more work since the government is not carrying the main brunt of the case. So, again, the incentive is huge to bring the case and collect a substantial percentage of the collections that the government ultimately will make. There are certain fairly recent amendments that have encouraged the filing of more key TAM actions and False Claims Act cases. When we combine these amendments with the increased emphasis on enforcement in the trade remedies area by the U.S. government, we can pretty easily see why there are more cases recently. Amendments that have had the effect of encouraging more cases include mainly three things. One is that we have to understand that the violation is not simply, can be simply that you knowingly avoided a charge rather than actually making a false statement. And for those of us who work a lot in the customs realm or in trade generally, that's a substantial difference. You don't have to actually make a false statement. You can walk up to the edge and still be in trouble, even though you didn't actually technically make a false statement. Secondly, the exact amount of the obligation that was owed to the government is not necessary to know for the false claims action to take place. So in other words, that becomes important in places like anti-dumping duties or in other duties as well. But anti-dumping is probably a good example of where it's important, because at the time you enter the goods into the United States, you don't necessarily know how much money is owed as a final matter. But as long as you know that something is likely to be owed, it's going to be enough to bring a false claims action. And then thirdly, there have been changes regarding the exact meaning of public records in the statute. And the reason that's important is that simply relying on public records by the relator is not going to be enough. You can't go to the New York Times and simply say, oh, I saw something, I'm going to file a case. They must have done something wrong. It's not going to fly. You need to have a bit more independent knowledge, however that comes about. If you're a defendant in one of these cases and you end up with a case filed against you, of course, you're going to have to think about who you're going to hire as counsel, what kind of background you want people to have. And really a substantive knowledge of trade and customs is going to be important, because that is the substantive background of the cases, but also an ability to do litigation in the jurisdiction where the case was brought. And I say that because these cases, false claims actions, are not brought in the U.S. Court of International Trade, where most actions are brought in the trade remedies. In fact, all really meaningful actions on trade remedies are brought in the U.S. Court of International Trade in New York. These cases are brought instead in U.S. district courts throughout the country, and that would include, California, New York, Illinois, any of the big jurisdictions, Texas, and many other states. Those firms that and companies that defend effectively will try to combine both knowledge of the local jurisdiction along with people who know the customs and trade law. So, as I mentioned before, and this is in some ways the most important thing perhaps, liability doesn't attach for just making a false statement or making a false or submitting a false document. For the False Claims Act to apply, and you have the description in front of you right now, it says that all you have to do is to knowingly make, use, or cause to be made false statements, a false record, material to the obligations to pay or transmit money to the government, or, and this is probably the most important part, knowingly conceal or knowingly and properly avoid a decrease in obligation to pay or transmit money to the government. So that's a really broad standard. I mean, obviously, the plaintiff is going to have to prove that whatever you did, if you're a defendant, was knowing. But it's not, again, it's not a false statement by itself. It simply is that you knew, and it's a tougher standard from the point of view of a defendant, obviously. Key TAM actions that are brought by relators are barred if they are based merely on publicly available information. And in the trade realm, there's been a lot of controversy about exactly what that means. And the courts really haven't totally sorted it out yet. But databases such as Peers, which a lot of people use to track imports, is that a public source of information or not? Courts have not been completely clear on that issue. Is it news media, or because it's a subscription service, is it somehow different? Lawyers have argued both sides. I mean, clearly this isn't the New York Times, but on the other hand, anybody can buy these subscription services that want to. So that's yet to be totally sorted out, but it's an important issue because some of the allegations are based mainly or largely on such subscription services. What's clear, though, that is the relator needs to have knowledge that is independent of and materially adds to any publicly available information. That's a sort of vague statement, but it's more than just giving it a fly and try to see if it works. That you want to make an allegation. Many of the issues are very fact specific, and as I said, the law is still being developed in that regard. So what kind of customs and trade actions have the false claims actions been used for? At least one case has involved the alleged failure to mark properly under 19 U.S.C. 1304. Several cases have involved misidentifying or misclassifying products in order to avoid anti-dumping duties. Other allegations include circumvention or evasion of dumping duties by further processing in third countries or outright transshipments. And we expect these same principles may be applied to imports that allegedly are misclassified under Section 301 or 232 duties. We haven't really seen much of that yet, but those duties are, relatively new, and these cases take a bit of time to work their way through the system. So there's obviously a lot of goods involved in 301 and 232 duties, so we may see a lot more of that coming down the pike. So what's a company to do if they get a case? The answer is not always easy because, as I said, the cases are generally filed under seal and are not revealed publicly until the government either decides to take over the case or declines to do so, in which case the relator can bring the case itself. So this lack of transparency in the law really works against companies trying to be proactive. However, we have found that many times a company will at least have some knowledge that either a competitor or possibly a disgruntled former employee has been starting rumors about illicit behavior at a company, about misclassifying or evading duties, for example. And so if you hear such rumors, it may be a good idea to consult early on with a lawyer, and you can objectively begin to assess whether you have any vulnerability in this space. Better to have time be on your side than the other way if you hear such things and take them seriously. And frankly, it's unlikely to be a long or expensive undertaking to do an initial assessment on your vulnerability. Of course, if you find that there may be some problems, it's going to be more complex. But generally speaking, it's not going to be an incredibly complicated undertaking. And of course, I guess it goes without saying that if a case has been filed, it's important to act quickly to hire counsel and to begin a defense. We've certainly seen a lot of companies out there who simply wait, it's obviously time is not on your side once a case has been filed. So what we're seeing, I think, is because the government has its own agenda on trade to crack down in every way conceivable, I think we'll see more cases from the government. But where we really have seen the uptick recently is from private competitors. Companies, for example, who file an anti-dumping case and then continue to follow and monitor it and follow up and ask for reviews in that space, or U.S. companies, for example, who support the 301 or 232 duties, and then come through as a relator much later in the case and decide that, well, we're going to also bring a key tam action to see if we can actually collect some money for ourselves as well, because we know the case and we can assist the government as to where to look for where things might be wrong. So that sort of summarizes what I've got on this. I will turn it over now to Bob Stang to talk about his forced labor issues.
Thank you, Jeffrey, and welcome to those of you who are logged in this afternoon. And as Jeffrey mentioned, we've included both of these, forced labor and Jeffrey's presentation, because they both involve statutes that have been around for quite a while. And now the statutes are gaining a lot more prominence and affecting a lot of folks. So with that, let's move to the first slide, please. So the statute for forced labor purposes is 19 U.S.C. 1307. And let's talk for just a second about what does that statute actually cover, and then let's talk about how that statute has actually changed. The statute covers all goods, wares, articles, and merchandise manufactured wholly or in part. And wholly or in part is very important, because what that emphasizes is that the statute covers not only the finished goods that a company might import, but it also covers finished goods that happen to incorporate the prohibited goods as an intermediate component or a raw material, something like that. So we're not just talking about the finished goods that somebody might import. Additionally, it doesn't just cover merchandise that happens to be manufactured in the country of export. So if you have a situation involving a forced labor, goods manufactured with forced labor from China, you actually could have goods from another country that are stopped and prohibited from entering if they're manufactured with those forced labor goods from China. And we'll go into that in a minute and give you some examples. So what's changed in this statute? Well, in TFTIA, the Trade Facilitation and Trade Enforcement Act of 2015, that was effective in March 10th of 2016, they repealed the consumptive demand clause. And the consumptive demand clause, it said that if the goods were not produced in such quantities in the United States as to meet the consumptive demands of the United States, then actually this wouldn't apply. So when they took that away, obviously that really expanded customs' ability to deny products made with forced labor. So let's go on to the next slide, please, as to what has changed. And the next thing that we think that has changed is customs policy in this area. And the quote that we have up here, CBP does not generally target entire product lines or industries in problematic countries or regions. That's taken right from the customs website. Well, if you look at the more recent withhold release orders, so let's look at the one issued in January 13th on cotton and tomato products from China that's been getting a lot of attention. That one says that the order was issued against cotton and their downstream products produced in whole or in part in the Xinjiang region, the XUAR. So think about that, cotton and their downstream products produced in whole or in part. Well, that absolutely is an entire product line or an industry. And what that means, for example, is, let's say you're a company that's importing cotton shirts from China. Well, you have to be concerned not just about the finished goods, the cotton shirts, you have to be concerned about the fabric that was used to manufacture the cotton shirts, the yarns that went into the fabric, and even the raw cotton. And we note also that Customs has recently instituted a policy where they will deny entry to the goods if they think that there's any chance that the prohibited goods were commingled with the legitimate goods. So in our opinion, that's a pretty significant change. And also, I think a number of folks know that there was a withhold release order issued just last week on the Husch silicon industry, and that one also covered silica-based products made by the company and its subsidiaries. And once again, we think that that's going to be an example where Customs is not going to necessarily limit itself to a specific product, but it's really going to be a much more general group of products. So what has not changed? Let's move to the next slide, please. Well, one thing that has not changed is the regulatory standard. And the regulatory standard is that they can issue a withhold release order if the information, quote, reasonably but not conclusively indicates that the merchandise was manufactured with forced labor. Reasonably but not conclusively. Okay, so what does reasonably but not conclusively mean? Well, reasonably, at least in a civil context, oftentimes means a preponderance, more likely than not, slightly more than 50%. Okay, so you can now all of a sudden see Customs is targeting a much wider range of goods. And what kind of information do they have, excuse me, to be able to issue a withhold release order? They don't have to conclusively arrive at a determination. They just have to have a reasonable determination. We would also point out, by the way, that the information provided to Customs, enabling Customs to make that decision, also falls far short of conclusiveness. The information that's provided to Customs merely has to meet the, quote, the reason to believe standard. So that has not changed, and the point is that Customs can make these decisions with information that is far short of anything that's conclusive. So moving to the next slide, please. One more thing that has not changed. And that one more thing that has not changed, which I think we would all agree on, is politics. Okay, Democrats and Republicans, they can disagree about everything, it seems, except for one major policy point, and that is getting tough on China. And I think that we can look at the background of the current USTR. And I think that we can just also look at the recent withhold release order that was issued on the silicon products. And also there's a new legislation working its way through Congress called the Uyghur Forced Labor Prevention Act. So the forced labor, it's here to stay. It's something that is very attractive to Democrats and Republicans, and it's not going anywhere. So moving on to the next slide. Where does that leave us? Well, first of all, as of last week, and this was before the silica withhold release order was issued, the information was that withhold release orders, WROs in place, covered 156 goods from 77 countries. 156 goods from 77 countries, and keep in mind that customs now can enforce this against goods that just incorporate the prohibited materials. So you could have a product that has never been detained before, but if it incorporates cotton in it, it opens the door to detaining that product. Our reports are that there were approximately 400 detentions based on withhold release orders in the past 12 months. If you just look at the number of WROs that have been issued since 2018, there were 28 issued. In the 60-some years before that, there were 39. So you can see there's a real uptick. Now, some similarities between this statute and the statute that Jeffrey was talking about. First of all, unfortunately, we believe that this statute is being enforced with a lack of transparency. Customs has advised that it has significant evidence for the detention, but importers that are faced with these detentions, oftentimes they're never provided with the source or the nature of the goods. And we are also aware of one instance, at least, where the information provided to customs triggering the WRO, in our opinion, was based on false information provided by a competitor to the company. Second, we think that there is a broad and vague interpretation of the WROs. So for cotton goods, for example, we're aware of a situation where apparel was manufactured in China using U.S. cotton, and was manufactured in factories thousands of miles from the ex-UAR. Customs is thinking about it. Customs has also said that they're going to raise issues of commingling. Commingling means if you provide all of the information to customs showing that the prohibited merchandise was not in your product, customs is going to say, well, how do we know that the yarn manufacturer didn't take some prohibited cotton from the ex-UAR and mix it in with your cotton? In other words, it puts a burden on importers to prove a negative. How do you prove that something did not happen? It's very, very difficult. We've tried to use it with affidavits, but that establishes a standard that many people just can't meet. We also have reports that customs is investigating cotton goods from countries other than China. So in other words, if you manufacture apparel in Jordan, okay, we think that you have to be concerned, Jordan, Egypt, or anywhere in the world for that matter. The question then becomes, where'd they get the cotton to manufacture those goods? We're also aware, by the way, that customs is not acting expeditiously on information that's submitted. We've had situations where information has been submitted and customs is sitting on it, and you can never get a clear answer. And in the meantime, the goods are accruing storage and demurrage and all kinds of things. So with that, next slide, what to do? Well, in terms of what to do, we think that you have to look, first of all, proactively, and then reactively if you're faced with one of these. Proactively, a lot of this would seem to be common sense, but it really involves, you have to take into account cost and corrective actions, but it really involves knowing your supply chain. Who's supplying what to whom? If you're in the apparel industry, where does the cotton come from? Where's the yarn manufacturer, the gray goods, the finished goods, and being able to map it out. We think that it's also prudent for people to conduct social compliance audits at manufacturers. There's a number of very good companies that do this. They're not necessarily cheap. And also people should be aware that if you do engage a company to conduct a social compliance audit, make sure they're doing it to customs standards. To give a quick example, we're aware of one company that did a social compliance audit, but did not geotag the images, meaning they didn't have the longitude and latitude and time and date when the images were taken, and customs refused to consider those. You should document your standards through a code of conduct and language and place that in the contracts, and make sure that you issue that to the manufacturers. Visit the manufacturers, and we understand that that is difficult now, but to the extent possible, or have an agent or somebody that's your eyes and ears do it. and by all means incorporate compliance into your internal controls and procedures so that if you see a weakness that you can correct it proactively. So next slide, what do you do if it's not on a proactive basis, but it's a reactive basis? It's after the fact you've imported the goods and you get a detention notice. Well, first of all, you should know that you have the right to export the goods at any time up to a seizure or abandonment. So that's a tough option for folks, but between exporting the goods and losing the goods, or between exporting the goods and taking the chance that they're going to accrue an immense amount of storage or demurrage, sometimes exportation can be the least painful option out there. However, you are also permitted to contest the detention administratively. If a redelivery notice was issued, you should be aware that the redelivery notice, the position of customs right now, and this is on the frequently asked questions for the XUAR withhold release order. They're holding themselves, we hope, to a 30-day rule, meaning that if the goods are released and 30 days has passed, then a redelivery notice should not be timely. Once again, if you're going to contest it administratively, map the supply chain and provide full documentation, including there's a special affidavit in the customs regulations, and we think that you should supplement that with a further affidavit indicating that there's no commingling. Remember, we said that customs is raising the commingling issue, and how do you prove a negative? We were told informally that that's one way or one piece of evidence that they'll look at. You, by the way, do have the right to protest an exclusion. The protest date would be the date that they issued the actual exclusion notice. We've given you the statutory citation there, 19 U.S.C. 1514A4. And it's very interesting that a court case is pending on a withhold release order. We've given you the name of the case in the Court of International Trade. I believe it's a palm oil issue, and that case is working its way through the courts on Section 1307. So next slide. What do we see on the horizon here? Well, first of all, we think that Customs realizes that the legal and administrative difficulties presented by its current process and procedures might be a little bit more than what they were anticipating. And we know that today and tomorrow, Customs is taking presentations from various folks in the industry seeking solutions to two significant challenges. That's their words. The first challenge that they're talking about is how to improve supply chain transparency to identify and guard against forced labor risks. How to identify supply chain transparency. I think that goes to the example we gave. You import cotton apparel, finished cotton apparel from China. How do you know where that cotton actually came from? The second thing is, and this is very interesting, that Customs says they want to examine the ability to verify the source of a product or a raw material. And we're aware that there are a number of companies out there that say that they can test your goods and that they can tell you where a raw material or component came from. We're also aware that in many instances, the costs that are being thrown around for that are exorbitant, and that the companies are requiring companies to agree to quite a few number of tests, and it just doesn't work for all kinds of fabrics or yarns. So, for example, if it's 100% cotton, that's great. But our understanding is that if the cotton is mixed with another fiber, then the test will not work. So with that, thank you very much. Kevin, we're going to kick it back to you. And if you have questions, Jeffrey and I would be pleased to take the questions until the top of the hour. Thank you very much.
Jeffrey, Bob, thank you so much for great content here while you guys situate yourself. We do have some questions that have come in. And again, I would encourage anybody that has some questions directly regarding these topics. We've got two excellent presenters here, reliable resources that I know I turn to on a regular basis for information in this ever-changing world of compliance and trade and so forth. So please be sure to write down your question in the Q&A section of the portal here that you're looking at. So I do have some questions. Bob, you just kind of finished up, so why don't I just kind of start with you? Can customs detain the goods if they are shipped after a withhold release order has been issued? And what if they are actually entered after the withhold release order was issued?
So that's a great question. A WRO is issued and the goods are shipped after that. And the answer is that you cannot enter the goods if the WRO has already been issued. And even more to that point, our opinion is that if you know that there's a WRO against the goods and you do import the goods, then you've also exposed yourself to penalties. So now the question comes up, well, what happens if the goods are entered and released and then a WRO is issued? Our opinion is that first, you do not have the requirement to go and report that to customs because when you entered the goods, everything was perfectly fine in that situation, assuming that it was. That situation, though, also brings up the point that we mentioned in the presentation involving a redelivery notice. If the goods are released, then we believe that customs has 30 days from the date of release to issue a redelivery notice. So the point being that you can have goods that are imported and they're entered and they're released, and then a WRO is issued. And even at that point, you could be faced with a timely redelivery notice requiring you to return everything to customs custody or face the possibility of liquidated damages, which would be significant. If once again, though, if the redelivery notice is issued after 30 days from the date of the customs release, then we believe that the goods should be free and clear and that customs should not have a basis to request redelivery. And if they do, we would encourage people to file a protest.
Excellent. Wow. So I'm just going to stay with you, Bob, because the camera's on you here. If customs detains my goods and I submit information within 3 months from import, as they've been designating, that goods were not produced with forced labor, then how long does customs have to act on my information? Good question. So there are a number of time frames built into the regulations, and that 3-month period is one of them, and that's the time period that the importer has to provide the information and documents to customs. But, and this is a really big but, there is no timeline on customs to make a determination on that information. So customs can sit on that information, and we have seen that in a number of instances, and it's really hard for importers to know what to do, particularly if they think that the goods are accruing storage or demurrage. And sometimes that's another reason why people get put in this situation where they don't know when customs is going to make a decision. And sometimes they just feel that exportation is the quickest and easiest way to stop the bleeding. And so even if they've provided all of the information or they know that the goods, or they strongly believe the goods don't have anything made with forced labor in them, sometimes people just decide to cut bait and export the goods. Yeah, that's certainly been a pain point I know that we've experienced with that, but I certainly have concerns on the export piece as other countries around the world start implementing their own increased forced labor regulations on the ability to subsequently export the goods once when this happens. That could be increasingly more difficult in the near future. I know, for example, Canada has implemented some increasing forced labor regulations. Do you see that as, again, could be a problem? And would there be any solution for that? Would it be destruction of goods? Would be your only solution then, or ride it out?
Well, so if you wanted to ride it out, okay, that's certainly a possibility. Another possibility is that even if customs issues an exclusion, a letter excluding the goods, once again, you have the right to file a protest, but then the question is how quickly will customs act on the protest? Although in fairness to customs, we have seen several instances where they've actually decided on the protest in a reasonable time period. But you bring up a really great point, Kevin, and that is, if you're going to export the goods, where do you export them to? In many instances, customs will not let people export goods to Canada or Mexico because they have concerns about the goods being shipped around the flagpole. And certainly if it's other countries that have the same kind of concerns, you don't want to just go from the frying pan into the fire. So what that indicates in a number of instances is that the goods have to go back to the country of origin. And obviously, can you get the container? How much does it cost? All of the freight, all of those sorts of things. So it raises a number of very difficult decisions for folks in a number of instances.
All right. Now, what if staying on this topic, what if the information that triggered the withhold release order has changed, or you provided information to customs for improper purposes, something like that?
Well, certainly the company importing the goods should never do that. The concern that we've had is that we've seen certain situations, at least one situation, where a competitor to the importer, we believe, provided false information to customs. We documented that it was false by taking very clear images of permanent structures that could not have been put in place easily or quickly. And customs isn't quite sure what to do with that, or they take the position that that they'll let the goods go going forward, but the goods that are currently covered under a detention notice, they won't give you any relief on those. So customs itself, we think, is showing that they're still working through a number of situations that forced labor issues provide, and exactly how they handle each one, that really depends on the level of detail that you can provide. If you look at the level of detail that they're providing for the apparel folks, in our opinion, it's onerous. It's unreasonable, frankly, in a number of instances, because they're asking for production records, not just from the actual manufacturer, but from the gray goods manufacturer, from the yarn manufacturer, from the raw cotton vendor, and shipping records and all sorts of things. And that's almost impossible to provide. But it really just emphasizes that it's a new ballgame these days, and people have to be more proactive, and they have to invest. They should be investing a lot more in this area because the consequences of not doing it, in our opinion, are potentially much worse than failing to invest in your compliance.
I agree completely, and it seems to me from the way that they're approaching the order, especially with regards to the cotton and so forth, customs has come out and they've identified that there's gaps in the customs process, and those gaps specifically relate to the origin of the goods. And I know that customs is going through this exercise called the 21 CCF, the future of the customs business, to see what the format of customs should be in the future. And it's going to be interesting to see how maybe some of the things that go on here might drive that need to acquire information sooner. But so my question to you, my last question I think I have, and then I'll turn over to some questions for Jeffrey is it possible to get a heads up on these WROs if they might be issued against, my goods?
We think that the answer is yes. And there's no one means of information for that. But if you just look at the cotton WRO, the XUAR, they issued a statement on forced labor several months ago. I think it actually might have been a little less than a year ago on that. And that was a clear warning to folks where they were going. In addition to that, you can see that forced labor issues are here to stay, particularly with China and particularly in the Xinjiang region. There's new legislation being proposed where they're talking about not just prohibiting cotton goods or tomato goods, but now they're talking about prohibiting all goods. And there was a very interesting statement from Senator Rubio with respect to that legislation, where someone said, well, do you think that anybody can ever meet the standard to avoid a detention of goods? And he said, no, he doesn't think that anybody will ever be able to meet the standard. So back to your point, Kevin, there are things that come out in the industry that show where the government is looking at, and customs in particular, or USTR in particular. There are a number of publications from USTR or from the ITC that focus on these kinds of issues, and we think that people should be paying attention to them more closely than in the past in order to make sure that nobody is surprised by this. Thank you very much.
All right, thanks, Bob. Let me turn over now to some questions for Jeff. All right, Jeff, I have some questions here. Number one, what do the plaintiffs in false claims cases tend to be? Are these cases brought on a contingency basis by law firms?
Generally speaking, yes. Most of what we've seen, at least, are contingency cases, which obviously encourages smaller companies who might be your competitors, or even probably more importantly, individuals who are former employees and disgruntled, to bring the cases. Increasingly, we've seen such cases being brought by competitors. It used to be more of the disgruntled employee type of situation, although we certainly see some of that as well. But those are sort of the two types that I would say most of the cases are brought by.
Now, in this situation, and I think I heard you say this, but I want to make sure, when you were talking about the liability for false claims actions, will that be in addition to any duties owed to the U.S. government under anti-dumping or customs laws or other laws, those kinds of things? Yes.
All of these are punitive duties and punitive things are brought. Penalties are brought in addition to what is owed already under the customs law or the anti-dumping law. So it can be, that's why I say, and I said at one point, it could be about the company situation, because when you add all this up, it becomes very substantial in some instances.
Gotcha. So I guess my big question is why? Why are we seeing an uptick in these false claims actions, and what should we do to protect ourselves?
Yeah, I think you're seeing the uptick mainly because people have become aware of the change in the law. I mean, more generally, lawyers who do this work have obviously been aware of it for some time, but I think that the lawyers who bring the cases have become increasingly aware that there's money to be made here. And I think that the companies out there who are competitors also have become aware that this is a vehicle that they could be using to not only hurt their competitors, but also make some money for themselves. So when you combine that with the what Bob talked about and what I talked about as well, which is the political atmosphere, which people tend to think, well, this is an easy mark, particularly if it's against China. Although it's not just China, it's other companies as well that have these actions brought, but certainly China is the bulk of it. That they think this is a good time to bring the cases. As I said, I think the best way to address it from a company's point of view is just be aware of who might do this. I mean, simply being aware that these cases are out there and that they're dangerous and that companies who are your competitors might bring them. If you've got an aggressive competitor out there that's constantly complaining to CBP or complaining at the Commerce Department in anti-dumping context, or if you have some employees that have left your employment, think about whether this could, possibly be turned into a case. And, it may not, you may think it's a lousy case, so you kind of ignore it, and that's understandable. But still, it might be, if you think they might bring a case, at least think about talking to a lawyer as to what you should do. Because time is not on your side as a defendant in these cases. And so the earlier you start to act and think about it, the better off you are.
All right, I got one last question here, I think. With the 301s from China, we've seen a lot of clients transition their supply chains out of China. So they're not producing there. They've moved to Vietnam, Cambodia. And with that action of now claiming made in Vietnam, made in Cambodia, made in Philippines, again, against a history of made in China, do you feel like that's going to lead to more of these types of cases? And would the importer be the one liable then for that False Claims Act? And is there anything that they should do in preparation if they're making these changes?
Yeah, that's a great question. And absolutely, that's what we see coming down the pike, in all likelihood. Both in terms of what you might call, just evasion, people just bringing something, for example, from China into Vietnam and slapping a label on it and just simply transshipping. That's an obvious one where, you've got somebody that you're working with in Vietnam. You don't know they're doing that, perhaps, but that's what's going on. That could put you at risk. Or transformation, not sufficient transformation, put a coat of paint on it or just do a little bit in Vietnam. Claim it's Vietnamese. It's not necessarily all that difficult to get something from one of the Vietnamese authorities, for example, because I've seen this myself, to claim this product of Vietnam. That's the reality of the world. So yeah, I see that happening. And some of these cases could be brought under false claims, even though they're not legitimate, but it really is a harassment tactic against one of your competitors. The preparation on that side of it is what we'd suggest already and have suggested for years, which is, as Bob said, know your supplier. The more you know who's producing it, the more you know about what they're doing, obviously, the better off you are. It becomes complicated, of course, to defend one of these cases because of, getting information from overseas, particularly now, obviously, because of COVID, but in any event. So the more you know going into it, the better off you're going to be if the time does come that you have to defend one of these actions against you, because the downside's huge.
Excellent. Well, we've come to an end. I want to thank Jeff and Bob for the incredible information in such a short period of time of an hour. I know we could probably have talked to this for even longer, but I want to thank you all for joining us today. We hope the information was helpful to you and your organization. As a reminder, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. And with that, this concludes our webinar. So thank you very much for attending today.
Thank you.